Harper, is it okay if you start?
Sorry. They're messing up instrument names. I can't take that.
Well, you're just going to have to and suffer in silence. Okay, a couple of things. First, today, course evaluations have opened for you to complete, and you can do that through, I think it's the 25th is the day they close. And they are really important. I'm not going to say that the numbers are that significant, to me at least, because they're just numbers, but the comments are very significant. I read them, I take them seriously, and if there are things that you think could be done to improve this course, either the way I teach it, the way the materials, anything, I would like to hear that. I have a thick skin, doesn't bother me. It's all about getting the class to be as good as it can be for students who will follow in your footsteps. So it's not like they will disappear into some void somewhere. They will be read and they will have an impact. And the scores, they are what they are. To give you an incentive to complete them, other than just my urging and asking you to, here is a deal I will make with you. Okay, everyone ready for this? If 80% of you complete them, so I'm setting the bar pretty high, but if 80% of you complete them, I will bring to the exam bourbon rum brownies. Home baked, okay? And these are some evilly good brownies, okay? Now, I will not let you eat them until after you turn in your exam, because I don't want anyone saying I was drunk when I took the exam. But on the way out, you will get a brownie if you want one, okay? But it has to be 80%. And I would check, the way we do this is I can check with the administration, and they can tell me how many people have completed. And you will have to, and I will check, our exam is on Tuesday, December 4th. I will check the Friday before, because I'm going to have to, get ready to bake these things. The Friday before, so you have to have completed them. I guess that would be the 3rd, the 1st, or the last day of November, whatever that is, whatever that Friday is. Okay? All right, so that's number one. Number two, as I just said, your exam in here is on Tuesday, December 4th at 9 o'clock in the morning. That is a very good sign, right? The fates are conspiring in your favor. The reason that's a good sign is because I have a total of 3 siblings. I have an older brother, an older sister, and a younger sister. My older brother and my younger sister, born 5 years apart, were both born on December 4th. So it's a good sign. Okay? It's a good sign. I don't know if you guys believe in omens, but I do. So there you go. Now, as to that exam, there will be a review session. And at that review session, the way I do it is you come with questions, and I stay and I answer as many questions as you have. Right? About the material, I will not answer questions about what's on the exam, obviously, but pretty much any other question I will answer. Sometimes they go for half an hour, sometimes they go for an hour and a half. I will stay as long as you have questions, okay? The question is, when do we want to do it? I assume you have an exam on Friday?
Yes.
Prior Friday?
Yeah.
What exam is that?
No, Tuesday and Friday, it's, torts.
So Friday is torts,
Yes.
the Friday before this exam. So I'm assuming that you do not want the review session before your torts exam. Any dissent on that? Okay, good. So the question is, we have basically 4 choices, I guess. Friday afternoon, Saturday, Sunday, or Monday. Okay? Is there anyone who would like, is your torts exam on Friday morning? Yeah. Is there anyone who would want the review in criminal law on Friday afternoon? Really? Okay, that surprises me a little bit. Still a minority. If it were me, I would want to chill after the torts exam, and B, get some time to study before I brought my questions to the criminal law review. But okay, there's at least some of you who would prefer Friday afternoon. How many of you would prefer Saturday or Sunday? That's pretty overwhelming. Anybody for Monday? A few stragglers. Okay, so our choices are down to Saturday and Sunday. How many people would prefer Saturday? How many people prefer Sunday? It's really close. Keep them up if you prefer Sunday. That's more people.
Can we say afternoon Sunday though? Like,
Yeah, it's not even Sunday morning.
Okay.
If you guys haven't figured out by now, I am not a morning person. So I'm going to just go ahead and arbitrarily say Sunday at 2. Sunday, I guess that would be December 2nd, and I'll let you know where. For our review session. As I mentioned to you in my email, we will also, on the 20th, the last day of class, have a voluntary session. It will not be mandatory, at which I will take questions, not about substance. I won't cover any substance, because I don't want anyone to feel like they have to be here, but about exam protocol, structure, approaches to exam, that kind of thing. So I think useful information, but nothing you absolutely have to have. Okay? Yeah.
What time will that meeting be? Will it be 10:20?
Regular class time.
Okay.
Because we are scheduled to meet on that Tuesday is a legislative Monday. So technically your Monday classes meet, but we will have finished the material. So that if you notice on the syllable, it says that class was reserved in case we got behind. And like by some bizarre miracle, we did not. And so, because I always get behind the syllabus. So that's what we will do. Because Monday classes meet on Tuesday. Okay? Anything on your minds? Yeah.
Yeah, I'm just curious about something. Why are mistakes in jury instructions so common? Is it really that hard to get it?
Judges are just fools. Well, there's a lot of different reasons. I don't think there's any one explanation for that. I think one is there are a lot of unsettled issues of law, right? Trial judges do their best. Trial judges have issues that have not been resolved, at least in that jurisdiction. They have good defense lawyers arguing for one view of the law. They have really good prosecutors arguing for a different view of the law, obviously each of which favors their side, and the judge has to make a call. And sometimes appellate courts just disagree. So it's not necessarily that you can say before the fact that, oh my God, the judge was just flat out wrong, ignored binding precedent, completely ignored a statute, etc. That happens on occasion, but usually it's, okay, that was a tough issue, and it could have gone one way or the other, and it's up to the appellate court to decide the law. And ultimately the state Supreme Court if it's a state law issue, the U.S. Supreme Court if it's a federal law, including a constitutional law issue. So I think that's a big part of it. I think another part of it, this may be a little more controversial, is a lot of judges, in most states, state court judges are elected. The result of that disproportionately is that trial court judges are, well, there's two results of that. One is that disproportionately trial court judges, especially with criminal jurisdiction, are former prosecutors. So you end up with quite a few errors that go in favor of prosecutions, because that's the side they came up with, that's the side they know, it's sort of ingrained into their mentality. And appellate courts tend to be differently constituted, and they reach different results. The other part of that is that when you have elected judiciaries, they are deeply sensitive to, well, I want to get reelected. And one of the best ways in many places to not get reelected is to be perceived as, and to be able to be attacked as being, quote, soft on crime. So they give jury instructions that tend to be pro-prosecution, hand out harsh sentences, that kind of thing. And so I think that's a part of it that can contribute to remember, you get a skewed vision, because if the defendant is acquitted, the prosecution has no right of appeal. So that's the end of the case. What we have are cases in which the defendant is convicted and they are challenging some aspect, whether it's introduction of evidence, jury instructions, etc. So you tend to get cases in which the prosecution won and the defendant is appealing something that went badly for them. And the things that went badly for them usually are going to be jury instructions or the admission of evidence. That can also be a big one. So I think those are at least some of the factors. But I don't mean to be I don't wish to come across as being overly critical or think there's some systemic problem with trial judges. I think most of the time trial judges get it right. And the last thing I'll say is, remember, there's another way in which you're getting a skewed sample. Cases in the case book are sort of cases that are chosen to be interesting, chosen to be controversial, chosen to raise these issues in a way that sort of spurs your interest. They're not the run-of-the-mill, everyday case, because those don't make them into case books. Those don't make it into case books. And so the vast majority of the times, trial judges get it right, and their rulings are affirmed, and a lot of times without even a published opinion by the appellate court. We just affirm by order. So don't get misled a little bit by what you see in the case book, because that's not the whole universe of the way trial courts are performed.
I saw a story, I think it was Texas, where a juvenile court judge was not reelected. So on the next day he went back to work and basically asked everyone who came before him if they had plans to kill anyone, and if not, that he let them go. Just let everybody go when that was not his usual thing. And he said that's what the voters want, apparently. So do judges have any, I know liability isn't the best word, but when they do stuff like that, is that just, you just have to take it, or?
That's what the voters want. I mean, that's contrary to all data, which shows that actually voters tend to want be tough. And if you're perceived as releasing or being soft, you get voted out. So the notion that you can be some bitter judge who lost re-election and take it out on the voters because you think, and that's just mind-numbing. The short answer is judicial immunity is a powerful, powerful barrier to being able to hold a judge liable in for any sort of to be sued. You can't sue a judge for official actions. It's almost impossible. Now, a judge like that could certainly be brought up on judicial ethics charges. And I think those would be open and shut. This guy's leaving the bench, right? So I'm not sure how much of a sanction that really would be, but that sounds like a pretty open and shut case. And I'm just trying to imagine the courtroom scene. Okay, raise your hands if you plan to kill somebody. Who's going to say yes? Mr. Johnson apparently is going to say yes.
These are kids
He wasn't.
too, right? They're minors, so.
Well, I don't care if they're 35-year-olds. No one's going to say yes to that question. It's oh, you got me. You found out my dastardly plot, and I'm just going to voluntarily say, yeah, sure, I did plan to kill somebody. When no one raises their hand, everyone goes home. So I would imagine the prosecutors the first thing I would do if I was a prosecutor, presumably in most cases, would be to immediately go to an appellate court and ask for either a writ of mandamus to compel the judge to reverse his order, or a writ of prohibition prohibiting him from carrying it out if it hadn't been yet. So there are means available to remedy shenanigans like that. Okay, let's talk about exculpation. Yeah, Ms. Clemens?
I was going to start if you were going to go with case.
Wow, that's quick.
On it.
Do not get into a duel with Ms. Clemens. She will outdraw you, and you will fall. Okay? She is very quick on the draw. Tell me about Lavoie.
Okay, so you have a pharmacist who's working really late at night. Doesn't get off until about 12:30 a.m. And he went and grabbed something to eat, then started driving home at about 1:30 in the morning. And there's a car behind him full of 4 intoxicated men who pushed his car along by bumping into the back of him. He had tried to brakes. They pushed him through a stoplight.
Which is, in and of itself is dangerous, because what does that mean for the cross street?
Yeah, well, I mean, you could hit a pedestrian, another car could hit you, you could cause a big
Right,
wreck.
because the cross street has a green light. If you have a red light, the cross street has a green light, a car could be coming. No one wants to go through a red light, I hope, much less be pushed through one against your will, okay? So they shoved him along they said for kicks, right? Because
Why not?
how better to party at 1:30 in the morning? So he finally came to a stop. Then what happened?
So they backed up just a little bit after stopping. He got out and had a revolver beneath his belt, which he had a permit to carry that gun. They got out of their car and advanced on him and were threatening him to make him eat that damn gun, mop up the street with him. And so they used vile and profane and obscene language toward him.
Now wait, Ms. Clemens. I'm going to assume that from Mr. Cannon to Mr. Williams, you included our gang of 4.
Okay.
Okay. Okay.
I'm back.
And what was that?
I'm in the back of the advance.
You're in the back.
Yeah.
Well, since Ms. Clemens was so eager to do this case, she's going to be the one who's out in front. Saying things like,
The
we're going
irony
to
here.
make you eat that damn gun, we're going to mop up the street with you. In hindsight, Ms. Clemens, looking back on your behavior, does this seem too smart to you?
What do you mean too smart?
Does this seem like this was a wise course of action?
No, totally not.
Why not?
Because the other person has a gun, and like, what are we gonna get out of this? We're obviously gonna end up in trouble in some way, in a car wreck or in
in
a
trouble, or
dead.
or dead, or dead, as ends up being the case with you, right? The lead in this whole endeavor. So, right, it's not a very good idea, in other words, to decide that you, for unarmed, drunk people, can antagonize and threaten a person who just happens to have a gun. You picked the wrong guy at the wrong time on the wrong street, right?
Yep.
And that might have been understandable, if drunken, when you were just pushing his car along, right? Once you knew he had a gun, that seems like it would have been the time to say, oops, big mistake here, but you don't. So Lavoie, what does Lavoie do?
Well, I keep advancing, and Lavoie shoots me, and then I die at the scene.
And what happens to Lavoie?
Well, at trial, the jury was directed to have a verdict of not guilty. Said there was insufficient evidence to warrant bringing any issue to the jury, and it was a justifiable homicide.
After he had been indicted for murder,
Yeah.
right? So what is the standard? And Lavoie is helpful to us basically for setting the ground rules that we're going to be looking at for the rest of the semester, basically, because Scopation will finish the semester for us. What are the elements or the ground rules for justifiable?
It has to be reasonable.
What
for me-
does?
Okay, it has to be reasonable for me to believe that I'm in danger of being killed or having.
You have to have reasonable grounds to believe. That's our first encounter in this body of law with this concept, and we will come back again and again and again. Reasonable grounds to believe. Not just anything, but what?
to believe that I'm in imminent danger of being killed or suffering great bodily harm.
Is in imminent danger of being killed or suffering serious bodily injury, great bodily harm, whatever you want to call it. Now, some jurisdictions add different things to this. You know, being the victim of a violent crime sometimes is added to this. But this is the core of it. Now, somewhere on this board is the word of the day. Now, Ms. Clements is already going to get a word of the day prize. I'm going to recognize hands. Don't shout out, Ms. Harper. I'm going to recognize hands for the person who can tell me what is the word of the day that's on this board. Mr. Williams.
Imminent?
Imminent is correct. Okay? An imminent danger. Now, why is imminent so central to the law of self-defense?
It goes back to the principle of you don't have time to act, so we don't want to punish that kind of emergent circumstance.
What are we, good, but give me more. What limitation or principle is it reflecting when we say the danger you're facing must be an imminent danger? Why would we require that it be imminent?
Retributionist?
No, Mr. Wiseman.
Is it to like kind of narrow the circumstances where this could be applied? So like you just don't want to give people this defense just for any kind of like if they were.
But why imminence? We don't want it like, that's true of this too, right? We don't want to have just any threat. It has to be a threat of death or serious bodily injury. But, so we do want to limit it, but what limitation is that reflecting, Ms. Hart?
For example, if you know someone's trying to kill you, you can't just, if they're only in the party stage, you can't just walk up to them and shoot them and say, oh, my life was in danger.
But why?
Does it go back to the blood cooling thing where you don't want to give it too much time?
Yes, in a way.
That it has to be in self-defense.
Well, yes, but why imminent?
If it's not imminent, then you could have other possible actions you could
And if you have other actions, if there are alternatives, what can we say about your decision to use force, especially deadly force?
that you premeditated?
That what?
That you thought
No,
about
not
it?
necessarily, but
I was going to say premeditated too.
By that point, it wouldn't be reasonable.
not that it wouldn't be reasonable, it wouldn't be what else?
Necessary?
Necessary. If the reason imminence is built into this test traditionally is the idea that if the threat is not imminent, if it's only on the horizon, then defendant has alternatives. There are other things you could have done. You're not faced with it right there. So you could have called the police. You could have retreated. You could have used other force other than deadly force, right? There's alternatives. Then the defendant has alternatives. If defendant has alternatives, then the use of force was not necessary. And so what is built into this is the theory in our tradition of self-defense law that the law of self-defense is a law of necessity and that it should only be invoked, at least successfully, when it truly was necessary. So this is meant as a proxy for or a measure of necessity. Okay? Questions?
Well, yes, about the case, so if we're not done.
Yeah, go ahead.
It's
About
actually-
this case?
Yes.
Yeah.
It's actually just a procedure question, where the district attorney, I guess, ask for a writ of error, what is that in terms of the concept of appeal? Like, it sounds kind of like an appeal, but it's not.
It's just a term for appeals. It's just a term, a now outdated term for appeals.
Well, I thought you said.
You're asking, remember, if the case has never gotten to a jury,
Oh, okay.
if the jury has never rendered a verdict, then the prosecution making a legal argument that there was at least sufficient evidence can say the trial judge should have let this get to a jury without it raising it up.
I have a question. So I feel like making self-defense be out of necessity can be a little bit subjective. Like when people use like the stand your ground law as a defense for saying like they thought the threat was imminent, but like.
Well, stand your ground cases don't tend to be about imminence. The situation is usually right there in front of the person, and the questions are: does it make a difference that the law used to say that under some circumstances that we'll get to maybe Wednesday, that you have to retreat, that you can't stand your ground because it was unreasonable to stand your ground. And the current law in many states, including Kentucky, says no, you have no duty to retreat. I mean, that's what stand your ground laws do. They eliminate what had traditionally been a limited duty of retreat under some conditions. But they're not really about imminence. They're about the question. They are about necessity in a different way because they get at alternatives. The idea under duty to retreat was always that was an alternative, right? So it's a specific alternative, and we'll talk about what the rules were under duty to retreat versus stand your ground. Okay? Yeah.
This, I guess, kind of goes off of what she was asking, but I feel like the term itself, imminent, can also be very subjective on what, like, I guess, reasonable person would believe is imminent danger and what the court would view as imminent danger. I feel like there could be a disjoint.
Well, like any issue of fact, a fact finder of fact has to decide. Both, those are two different issues wrapped up in your question. One is, did the person have a reasonable belief? And as we'll see, a separate question is, was the belief correct? Because there's a difference between a correct belief and a reasonable one. So a fact finder has to find this, and it's not unique to self-defense law that we make judgments about reasonableness. We saw that in mistake of fact, or mistake generally. A reasonable belief can negate mens rea, right? So we've seen reasonableness before. I don't think that there's any particular reason why this is any harder for the fact finder to determine in the point of self-defense. Similarly, with imminence, there may be many problems with imminence, and we will talk about some of them when we move on in the cases. But I don't know that there's something unique that is hard for a fact finder, usually a jury, to decide about whether a threat was imminent with proper instructions. Right? There are lots of tough fact questions juries have to resolve on, given the fact before them, the testimony before them, evidence of witnesses, all of that. But I don't think this is uniquely a problem. I don't think this is uniquely a problem. As I say, it may raise other issues about the kind of policy we want to have when it comes to self-defense. But the issue of whether a fact finder can decide, was the threat imminent? I think fact finders make decisions like that all the time. Should they be making that particular, how much significance should we attribute to that particular fact finding? It's a whole other question. Maybe we shouldn't, maybe we should. Okay? All right, I want to talk a little bit about Kentucky law here. Insert this into our conversation at this point. Kentucky has a fairly systematic, and I'm going to put aside duty to retreat versus stand your ground for right now. I'm just give the basic framework apart from that, and we'll get to standard ground a little bit later. KRS 503.050 subsection 1 is very similar to the Model Penal Code, by the way. Model Penal Code 3.04 is also in your book. But KRS 503.050 says, the use of physical force by a defendant, notice here we're not talking about deadly physical force, we'll get to that in a minute. The threat of physical force by a defendant upon another person is justifiable when the defendant believes that such force is necessary to protect himself against the use or imminent use of unlawful physical force by the other person. So it's the use, this is KRS 503.0501, the use of physical force is justified. Force is justified when the defendant believes the use of force is necessary to defend himself against the use or imminent use, there's our word again, of unlawful physical force. And then the last part is by the other person. Okay? Now, those of you, how can I say this? I'll just say this. This is really important. Right? You cannot use self-defense if the person that you're saying, oh, they used force on me first. If their use of force was lawful, too bad for you. So you have to show, in order to use this defense, that their use of force that you're responding to was unlawful in the first place. Okay? Did you notice anything interesting about that?
About what? Unlawful or the whole thing?
No, about the whole definition.
That there's no word, the word deadly isn't in there?
Well, deadly we'll get to. This is just, deadly will be a whole separate section.
It could be imminent or not imminent?
Well, but the actual use is easy, right? But it includes imminence. What else?
I think that it's weird that it's just that they have to believe it.
As opposed to?
As opposed to it actually being imminent.
Well, that's true here, right? Believe was here, but that's what's not there. What?
Reason.
As opposed to it being correct.
Well, that's true in the other definition too. That's true from the other definition. It's
reason.
Reasonableness isn't there. Just believes. The defendant can have the most outlandish belief about the necessity and facing the use or imminent use of force, but it just says belief. Right? So any belief you might have, totally subjective, no reasonableness requirement. Is that right? Is that right?
Surely that can't be what it...
Surely not. Please don't call me Shirley.
Sorry.
Mr. Clapp.
In other situations, haven't the courts read into a statute?
Do they have to here?
No, but would they?
Why would they not have to?
I think imminent kind of has a sense of reasonableness to it.
No, because you have to just believe that it's imminent. Doesn't say you have to reasonably believe it's imminent. Maybe I'm hiding something from you. What am I hiding from you?
You said unlawful somewhat?
No, it's not it's not here, but it's somewhere. Where is it?
Are they inferring from legislative purpose?
No. I got some text for you. Who can find that text for me?
Me?
Yeah.
It says that they're presumed to have a reasonable fear.
No.
Is it
subsection 2?
No, it's not subsection 2, but it's somewhere. Try 503.120. KRS does it in the most indirect way, but what 503.120 says, subsection 1 of 120 says, if the defendant is wanton or reckless in believing the use of any force or the degree of force used to be necessary, or in acquiring or failing to acquire knowledge or belief which is material to the justifiability of his use of force, then the justification afforded by everything between 050 and 110, which will fill in the blanks there, the rest of 503, is unavailable in a prosecution for an offense for which wantonness or recklessness suffices to establish culpability. So if you have an unreasonable belief because your belief is wanton or reckless, or you are wanton or reckless in not acquiring important information that would have informed your belief, then it does give you a partial defense to crimes of knowing or intent. But it only mitigates it down to a crime that would be wanton or reckless, depending on your mental state. If they find you were wanton, then you can be guilty of wanton crimes. If they find you were reckless, you can be guilty of reckless crimes. Right? So if it's a homicide situation, and they find that you had a belief, it was an actual belief, but it was wanton or reckless, i.e. unreasonable, maybe, and wanton being more unreasonable, reckless being somewhat unreasonable, then you would be acquitted of, say, intentional murder, but you might be guilty of reckless homicide. Everyone see that? How those work together? One, this imposes the reasonableness requirement, and the reason they did that, I think, is because they could do it all in one section and apply it to not only 050, but the rest of 503 from 050 all the way to 110. And then the reasonableness requirement would be the catch-all. Okay? So there is a reasonableness requirement. Court didn't have to read it in. They didn't have to infer it from any other term here. This legislature did provide it. They just provided it in a separate section. Okay? Now, somebody who said there's nothing about deadly physical force in subsection 1? What does subsection 2 say?
I actually don't.
Of 050. Anyone? Who has the actual excerpts with them? Ms. Allen.
That deadly physical force can be a justification when the defendant believes that such force is necessary to protect himself against death, serious physical injury, kidnapping, or sexual intercourse compelled by force or threat.
So 0503.0502 is for deadly physical force. And we raise the bar in terms of what the defendant had to believe reasonably he or she was facing. Not just unlawful physical force, but give me that again. They must have been facing the threat of death, serious physical injury, kidnapping,
or sexual intercourse compelled by force or threat.
Or, I'm just going to shorten that to rape. Sexual intercourse by force or threat. Okay? If you face one of these things, you can use deadly physical force. If you face just this, then you can't use deadly physical force. You can only use physical force. And the particular case may come down to, okay, I believed I was facing, let's say, serious physical injury, not just physical force, and that's the prosecution says you didn't really believe that, or that belief was unreasonable, etc. What was the belief? Okay? 503.070 permits the use of force for the protection of another. Not self-defense, but protection of another. Again, it must be believed to be necessary, and then reasonableness in that belief comes in here. But it must be believed to be necessary to prevent the use or imminent use of unlawful physical force against another instead of against the defendant, him or herself. The individual must believe, that is, the defendant must believe, that under the circumstances, the person whom he or she seeks to protect would him or herself have been justified in using such protection. Okay? There are limits. 503.060 defines circumstances under which the use of physical force is improper. And I'm going to give you 3 of them. 503.060 says you can't use physical force in these 3 situations. 1, the individual is resisting an arrest by a peace officer, i.e. a policeman usually, who is recognized to be acting under color of official authority, and if that officer is using no more force than reasonably necessary to effect the arrest, even if the arrest is unlawful. So what are you supposed to do? What is this section telling you to do if you are being arrested, again, assuming the officer is using no more force than is reasonably necessary, but is arresting you unlawfully? Well, again, they're using no more force than is necessary to effect the arrest, so we're going to assume if they're giving you a beating, then it's more than is necessary. So that you can arrest. But what are you supposed to do if you're being arrested, again, without unnecessary force, and you think it's an unlawful arrest?
Oh, comply until you can get off, I guess.
Exactly. You challenge it later. The law is sort of telling you, if they're using unreasonable force, the officer is, then all bets are off. Right? But if they're using reasonable force, and the only objection you have is you think the arrest is unlawful, because there's no probable cause, etc., then challenge it later. That's what this regime sets up. Okay, that's one time in which you can't use physical force to resist arrest by a peace officer unless they're using unnecessary physical force to do it. Second, when the defendant provokes the use of physical force by such other person. So if